5 seconds to go. Start. Now turning to some of the judicial pronouncements, wherein it has been opined that the words used in a contract of insurance must be given paramount importance, and it is not open for the court to add, delete or substitute any words. Bracket start. Surajmal Ram Nivas Oil Mills Private Limited versus United India Insurance Company Limited. Bracket close. Stop. Insurance contracts are in the nature where exceptions cannot be made on ground of equity, and the courts ought not to interfere with the terms of an insurance agreement. Bracket start. Export Credit Guarantee Corporation of India Limited versus Garg Sons International. Bracket close. Stop. Para. This court in Vikram Green Tech India Limited versus New India Assurance Company Limited reiterated that the insured cannot claim anything more than what is covered by the insurance policy. Stop. The terms of the contract have to be construed strictly, without altering the nature of the contract, as the same may affect the interests of the parties adversely. Stop. The clauses of an insurance policy have to be read as they are. Stop. Consequently, the terms of the insurance policy, that fix the responsibility of the insurance company must also be read strictly. Stop. Para. In several other judgments, this court has held that the insurance contract must be read as a whole, and every attempt should be made to harmonize the terms thereof, keeping in mind that the rule of contra proferentum does not apply in case of commercial contract, for the reason that a clause in a commercial contract is bilateral and has mutually been agreed upon. Stop. Para. Now we turn to the specific clause in the MOU, which would govern the insurance policy providing for payment of compensation in the event of death only, resulting solely and directly from the accident caused by external violent and any other visible means. Stop. On a plain reading itself, leave aside the question of strict interpretation of the clauses, it is quite apparent that the admissibility of the claim is in the event of death. Stop. The second part of the same sentence begins with only. Stop. Thus, even in the event of a death, it is only in the scenario where the consequent situation arises, that is, it has to be solely and directly from an accident caused by external violence. Stop. Here the death is by sunstroke. Stop. There was no semblance of any violence being the cause of death. Stop. The last aspect, which reads as any other visible means, would be an expression to be read in the context of ajus dem generis, is with the external violent death, and cannot be read in isolation itself. Stop. Para. We have benefit of elucidation in this behalf arising from the judgment of this court in Alka Shukla versus Life Insurance Corporation of India. Stop. The court noted the divergence of opinion of courts between courts across international jurisdictions, making a distinction between accidental means and accidental result while deciding insurance claims. Stop. Thus, an unexpected accident and unforeseen consequence or result from a normal or routine activity may constitute an accident, but it would not qualify as accidental means. Stop. Two illustrative examples given are: a fatal heart attack while dancing would be called accidental, but would fail to attract insurance cover as not due to accidental means, semicolon. Heart attack suffered as a result of overexertion on being chased by a ferocious dog, the death might attract the insurance cover as it was caused by accidental means. Stop. In the first example, it was a normal activity, while in the second, it was an unintended activity and not a normal activity. Stop. The given type of injury may thus, fall within or outside the policy according to the event which led to the death, and it is this particular cause which is required to be examined. Stop.